Further hearing in the appeal, Secretary of State for Transport against Curzon Park Limited and others.
Mr. Pereira.
May it please you. So to conclude my submissions from yesterday on reality versus assumption, first of all, it's clear from section 14 in my submission that when valuing my client's land, AAD applications solely on other land or a certificate solely on other land are not things that exist in the context of the valuation of my client's land, and they're not allowed to affect value under section 14. And as explained by all the respondents, the applications and certificates are not pre-existing features of the market in the scheme cancelled world. So for those hypothetical things to be treated as real things and to have actual influence on decisions, in my submission, some statutory provision is needed, firstly to assume them into existence, and secondly to define their role. And the point on construction I made yesterday is reflected in the finding of Lord Justice Lewison at paragraph 62 of the Court of Appeal's judgment. For your note, that's page 339 of the bundle. My second heading was about equivalence, and I made that submission yesterday, the point being that section 14 only gives partial redress for scheme impacts. It doesn't give a full equivalent redress. So the third point I wanted to make was on certainty.
Excuse me, just one minute. No, I can put. Beg your pardon, thank you.
The cancellation assumption, as explained in Fletcher Estates, does not permit the decision maker to create the world that might have existed had the scheme been cancelled. And all parties, including the Secretary of State, accept that the Section 14 cancellation assumption is to give effect to Fletcher Estates. See the Secretary of State's case, paragraphs 90 to 92. That's in the core bundle, pages 246 to 247. And indeed, the Secretary of State emphasises that one of the roles of the cancellation assumption is to create certainty in the valuation. That's paragraph 92 of the case. So the market principle, that it's facts known to the market at the valuation date, tells us under section 14 that we can't create a what-if scenario. But Fletcher Estates also tells us that, and it's important to realise not only was Fletcher Estates looking at, I accept, the earlier statutory provisions, but there are 2 pages in the judgment which I'll give you the references to. So it's Authorities Bundle 7, and it's pages 817 to 818, where Lord Hope refers to wider considerations that support his conclusion, and those are, in summary, that an investigation into a what-if world would be unreliable and would result in needing to uncover obscure facts, and is something that the planning authority is not generally competent to do. Planning authority is not generally competent to investigate what might have happened if. And importantly for landowners, it's important that landowners know their rights and that advisors can tell claimants what their land is likely to be worth. And that again is frustrated if the valuation depends upon a recreation of what-if circumstances. And that's why I gave the answers I gave yesterday to the court in relation to this question of what evidence could be adduced in the CAAD cases before the tribunal, that if the evidence is relevant, then yes, it could be, but I don't accept that evidence to recreate a world is relevant. And that's also why it can't simply be assumed that developers would want to maximise land value, and so all the respondents would have brought their land forward at the valuation date. Because if that assumption is made, it assumes that they would have been ready to bring their land forward at the valuation date. And if that's to be shown, by evidence, it requires an investigation of circumstances prior to the valuation date. When would they have started to formulate their proposals? Would they have been thinking about it, and so on? But it also opens up another inquiry, if that presupposition is to hold good, which is that at any time since the cancellation date, presumably there might have been other forms of development which would have been of value to the developers. And so presumably then it would be relevant to look and see if any of the respondents might have decided to undertake other forms of development in the years since cancellation, so that their site may not have been available at the valuation date. And of course, once this door is opened, the sky is the limit. What of other parties? What of third parties who might have developed schemes or might not have developed schemes had the scheme underlying the acquisition been cancelled? What of changes of policy that the planning authority might have undertaken if the scheme had been cancelled? These are all the kinds of things that are discussed in Fletcher Estates and dismissed as being an appropriate way to look at valuation once the scheme is cancelled. So essentially, and to conclude, the Secretary of State's case really makes a claimant's land contingent upon unpredictable and largely unknown steps taken by other claimants in their compensation claim after the valuation date, usually. And perhaps as I end my submissions now, there's another claimant walking into the planning authority in Birmingham City Council making a certificate application which will impact the value of the respondent's land. We don't know, but that would be relevant. Perhaps it will happen next week.
There are two different points, though, that you're making really on there. One is that this is all too speculative.
Yes.
But the other is you're not allowed to look at it anyway.
Yes, indeed. Indeed. And in conclusion, and the market at the valuation date would never have known about it.
That's the second point.
Yes.
But I mean, the market would have known of the circumstances at the valuation date,
yes,
including sites being available.
Yes, the condition of the land,
yeah,
how planning policies might have applied to them, those kinds of things.
And how developers would be likely to react in those circumstances.
Yes, how they might have done, but how a particular developer, a particular developer might have done had the scheme been cancelled is not something the market would have known about.
So, yes, so the consequence of having to look at matters known to the market at the relevant valuation date is that, if you like, it's an assessment that needs to be made, but at quite a sort of level of generality, looking at how people usually behave. You can't look at how specific individuals might have behaved, because that wouldn't be known to the market.
Yes, yes. And as soon as...
Sorry, just to pursue the point, doesn't that then cut both ways? Because if one's looking just at how developers usually behave, and you exclude things such as their subjective reasons they might have that the market doesn't know about for holding back land and so on, usually one would expect developers to bring forward land for development.
Well, at a level of generality, a planning authority can have in mind what developers generally do. But when looking at what might happen in relation to a specific site, that doesn't depend upon what developers might generally do. It depends on what the person controlling that site would actually do. That's a very different question.
What then is the difference between the prospect in 14.2 and the reasonable expectation? What is it that gets you from your land being valued on the basis of a hope,
yeah,
because there's only a prospect of planning permission, yeah, under 14.2, to saying, well, no, I had a reasonable expectation, yes, of the grant of planning permission, and therefore I'm valued not only on the basis of a reasonable expectation, but on the basis of a certainty because, yes, of this.
So yes,
there must be something that justifies that big jump up.
Yes, and there might be a number of things. So the reasonable expectation is generally taken to be, as the Court of Appeal explained, if it can be shown on the balance of probabilities that planning permission would have been secured, then it's treated as a certainty. But less than that, it's treated as a prospect. So for example, it may be that the planning merits of a particular site are quite controversial. So there was some hope of getting planning permission, but actually not that great. And so that would be a prospect. It would have some hope value, that it couldn't be valued on the basis of an assumed permission. And Section 14 also allows the prospect of development on other land to be taken into account. So, for example, at the valuation date, let's take a hypothetical case. Imagine there was third-party land that had the prospect of securing housing permission, and my client's land was next door to it. Well then, as part of the valuation of my client's land, I could argue that in the market at the valuation date, housing developers would be interested in my client's land because next door there was the prospect of there being a housing site. Now, that's not basing valuation on the certainty of a permission, an assumed permission, but it is acknowledging that the hope of a permission can influence value.
And could I just ask you a question following on from that and focusing also on what could reasonably have been expected to be granted?
Yes.
If one puts together the assumption that you are taken to know, the planning authority is taken to know only what's known to the market at the relevant valuation date, yes. So that will include, I think you accept, the circumstances of the land, its quality, yes. The planning policy environment, yes. And so on. And I put to you that the market generally would know how developers seek to maximise value, yes. From their land. One can't look, if that's right, at the subjective position of a particular owner of land, whether they're particularly keen to develop it or particularly keen not to develop it. But if one has the general background that I've just put to you, and one can see that there are additional sites which might meet a particular planning need, and one knows that developers usually seek to develop to maximise profits, why would it be said that someone could, or for one site, could reasonably have expected to get, if you like, the full planning permission that they maintain that they should have got on an AAD basis for that site, without taking account of what would have been a real consideration had planning permission actually been sought if other sites were treated as available?
Yes. So all of that question, if I might just observe, in its asking and in its answering, does not depend upon certificate applications.
No, I agree.
Or things. So that's the first point to make. But as a generality, if the circumstances on other land are such as would engage the various planning principles that Mr. Corner's looked at for when alternative sites might be relevant, then they would be relevant material planning considerations. But that just depends upon the actual facts known to the market, not the generality of facts. So, for example, in a normal planning case, if a planning application is made for a particular form of development, it's not normal, and in my submission it wouldn't be lawful, for the planning authority simply to say, this developer's coming forward with this development, but because there is other land in the area and that's owned by developers, we must also consider that they might, because their developers bring forward their land. I mean,
well, you wouldn't do that in an actual planning case, because you would have options to get additional information that inform you whether land actually is likely to be brought forward or is not. The difficulty with the no scheme world construction is that we're told you can't do that. You just have to look at circumstances known to the market at the relevant valuation date. And so you can't make inquiries as to the particular subjective strategy of any particular developer. But the market does know how developers generally act to maximise value.
Yes, in general, and at that level of generality, that can be considered. But bear in mind, a specific landowner might have a reason for not bringing forward the land. They might be waiting for an allocation.
Yeah, but if that's not known to the market, one can't take that into account.
No, but it's also a reason why one can't reliably make a decision based on an inference that rests on what developers generally do, because the general may not apply to any of the specific sites that the planning authority is looking at.
But if all you've got, because you're told that all you've got is the generality, what circumstances are known to the market, and what you're looking to is to identify what could reasonably have been expected to be granted by way of planning permission. Well, the question is whether if you put those two things together, doesn't that force one, in effect, to look at matters at a level of generality, how people usually behave, unless, of course, there happens to be some information which is available to the market which gives you a better insight into the attitude of any particular developer of another site.
I think 2 points to that. One can't be forced to do anything different to what a planning authority would do, because the hypothesis is that it's a notional planning application, and one is forced to obey the statutory language of circumstances known to the market. And so in a particular case, it might be that some general circumstances are of relevance. In my submission, normally they wouldn't be, because one's looking at what would happen on particular sites, and one doesn't, that's a matter for particular evidence. I suppose the point I'd like to emphasize is that the certificate regime and the assumptions under Section 14 don't enlarge the powers or the considerations that a planning authority would normally have.
No, I wasn't seeking to suggest that they did. It's just that it constrains
it does
how one, in the counterfactual world, assesses what a planning authority would do.
If anything, it does constrain, but that's a consequence of the statutory language, and that's to, in my submission, create certainty so that landowners can form a view on what their land is likely to be worth under the compensation code.
Yes, thank you.
Am I right that you say that the words "in the circumstances known to the market" mean in the circumstances that actually weren't known to the market at that date?
Yes.
Not such circumstances as would have existed and been known to the market in some counterfactual scenario.
And the sky's the limit on that. Once that door opens, although my learned friend's submissions are only confined to, his submissions are only confined to the other respondent sites, once that door is open, there is no reason in principle why it doesn't apply to all and any circumstances that might have been different had the scheme been cancelled. The door is either open or it's closed, and that rabbit hole was closed in Fletcher Estates in my submission.
The difficulty of transposing what you say would have been lawful or unlawful for a decision maker dealing with an actual planning permission application is that if you say, well, it would be wrong for them to refuse planning permission for an actual development that's being brought forward on the basis that there might be other developments nearby that would be better. But that isn't that because the making of the planning application might trigger those other people to get their act together and make their own planning application. But even if it doesn't, once that planning application has been granted and the need met, then they would be entitled to refuse planning permission to the contiguous land, whereas you say both that the decision maker is not allowed to take into account the potential of other sites beyond a very limited way, but when those other sites do make an application, the decision maker is also not allowed to take into account the fact that there has been a planning application made.
And the circumstances that were in the first part of that question, the circumstances of the real world, are exactly the circumstances that all our clients have been deprived of exploiting because of the scheme. It may well be that my client would have got the application in first and taken up all of the student housing or whatever other scenario might have arisen. But these are opportunities to liberate value which the scheme has deprived the landowners of. And so the way in which that is dealt with, which might be causing the reason for the question, is the way that Parliament has set out it should be dealt with, because There's got to be a choice made, put very crudely, about how the impacts of the scheme in depriving people of applying for planning permission is then reflected in valuation, and that's what Section 14 does. So the worlds can't mirror each other exactly, but it's Parliament's attempt to ensure that value that may well have been lost is captured in the compensation. And we have to respect that that's the balance that Parliament has struck. It could have used words which reflect the case that the Secretary of State's putting to you, but it didn't. I've perhaps overstayed my welcome.
You've very helpfully answered a series of questions which have been concerning various members of this panel. So thank you very much.
Thank you.
Mr. Glover, I think.
Indeed.
You have 30 minutes, I understand.
So I understand, yes, and the content of what I wished to say has increased and decreased with questions from the bench and answers from the learned friends. I hope to, as long as I put my foot on it a bit, to make sure I keep within the half an hour. May I start with an observation that flows out of the submissions my learned friend Mr. Pereira has just been making, and it is that we say this is fundamentally a case of statutory interpretation of Section 14. We say that because Parliament has decided that the compensation will not be assessed on the basis of the value of the owner's land in the scheme world, Parliament has to generate some assumptions and exclusions. And the way it does that is ultimately a policy decision. But as soon as one moves from the real to an assumed a hypothetical world, inevitably there are going to be points where, as it were, the shoe pinches, where the way in which, to mix my metaphors, the real world and the hypothetical world rub up against one another gives rise to questions of, well, is that quite logical? Is that quite, does that mean you're leaving something out? But in the end, the task is to construe Section 14, and you have our submissions on how that falls to be construed. The next topic I wished to draw attention to is to give just a word about CADs and CAD applications. To the extent that this is going over old ground, I do apologise. But in the real world, an applicant for planning permission identifies the development he wishes to promote, which may or may not be the most lucrative at the moment, and then he applies for that planning permission. In the compensation world, the landowner gets a certificate to cover all the potential development options, and then, with its valuer and other professionals, maybe costs consultants, identifies the most valuable, because that will be the basis on which he would wish to see his compensation paid. No consideration is given in that process to whether or not that development, forgive me, no consideration is given in this process to whether or to what development any actual or prospective owner would have brought forward, or when.
Absent this compulsory purchase.
Absent this compulsory purchase. We are in a world when we're looking at a certificate absent the compulsory purchase. Absent, amongst other things, anybody else seeking certificates. Just to emphasise that point with example, I draw attention to paragraph 7 of my written case, which is in the key bundle behind tab 5 at page 102. And this is showing what certificate was granted to my clients by the City Council and now subject to appeal by the Secretary of State. It envisages development up to 88,000 odd square metres, ranged in floor spaces, and you just see in the table the maximum floor spaces for each.
Where are we looking at?
Page 102 of the key bundle.
Are you able to give us the electronic file page? If there's working exclusively from that.
I think it may be 302.
I'm much obliged, Madam
Thank you. If so far as possible you could give us those pages too, it would assist.
I was under the foolish misapprehension that I was, so forgive me.
It is 302 of the...
302 of
The electronic file.
I'm not sure I do have many other references to give you to make that egregious error again. But what you see there is the development maximum of 88,000 odd square metres. And then in the table below, how that, this floor space of different uses. And it becomes immediately apparent that the certificate is actually envisaging a portfolio of possibilities. Now, the discussion has taken place in this room today, effectively on the assumption that the world would have known, did know, that student accommodation was the most lucrative, and in the Secretary of State's world, the assumption that everybody would want to develop the student occupation, but as a student accommodation. But as a matter of fact, all that the certificate does is provide a portfolio of development. Those are not proposals for development. They're uses proposed for inclusion in a CAD. And, as the world generally works, they're uses for proposals promoted in a CAD well after the valuation date at which all the decisions needs to be set. A CAD application and the CAD itself are scheme world documents designed for the single purpose of informing the valuation of the subject site. They are litigated only between landowner and acquiring authority. My neighbour is procedurally excluded from engaging in my CAD application and decision. So the question was raised yesterday about the possibility of my neighbour's managing director coming to the inquiry, or the appeal, rather, I should say nowadays, to the appeal in the upper tribunal and saying, well, had the scheme been cancelled, we would have done this, that and the other on our site. My learned friend, Mr. Pereira, has explained why that would be an illegitimate topic to discuss. But that managing director would only ever find himself in the tribunal if one of the or other of the parties called him to be there. He had no entitlement to be there himself. And I make this general point before moving on to my next topic. It is clearly not the positive intention of Parliament that my neighbour's CAD application and certificates should have a role to play in the assessment of anything beyond the remit being the assessment of the compensation on my neighbour's site.
I take it we don't actually have in the bundle at the moment your client's CAD application. I think we did ask for an example yesterday.
We do not have any CAD applications. We have all of the decisions.
Yes.
You did ask or raise the possibility, and you're repeating the request. We will make arrangements.
Sorry.
Are we being told that it has
Two
been
stooges, forgive us.
Yeah.
My Lord, I think Mr. Elvin's about to say what I am about to say. We can certainly make applications available. I know that, if it helps, my solicitors have just ready on electronic file the Quintain application. That's one of your clients.
as well.
All right, okay,
So-
sorry, I don't want to take up time if it's going to come in.
Would it be helpful? I'm not supposed to ask questions of the bench, but if it would be helpful, then we can do that. But it would be helpful to have an indication as to whether that's what you would like us to do.
I think it would be useful to see one, just to
Right.
give a flavour of what
Well,
not now. I mean, not particularly now.
but
I think we would all be grateful
Right.
to see one exemplar
Okay.
of these applications. We are not pressing you to supply it to us now, but we would be
Right.
grateful for it in the course of the next day or two.
Well, I'm sure we can do that. Can I suggest that, because I know, because we did discuss this in my team last night, as Mr. Elvin did as well, can I suggest that since we both discussed it and we appear both to have the same thing electronically, we just get our heads together after the hearing and we'll be able to send you that application in very short order.
Yes,
Would that be helpful?
may we take it that is agreed between
Certainly, Sir Elvin.
all the parties before us? Thank you very much.
Obviously, if you wished, you could have all of them, but I suspect you may not wish to have all of them.
I think a representative example would be
Right,
sufficient.
okay. We'll do that, my Lord. Thank you very much.
Thank you.
I get proprietorial about my time, but
Yeah, I'm so sorry, Mr. Glover. I didn't realise I was going to...
Now, please, yes, carry on. We'll make any appropriate allowance.
I'm grateful. I'm grateful. My next topic is just to remind ourselves of how we got here. Because I do suggest...
Can I just ask, with these uses that we're looking at page 302, so you get a certificate saying that all these would be appropriate development. Obviously, that all adds up to a lot more than 88,829 square metres. So then, assuming you've got an assumed planning permission then for all that, if you get the grant of the CAT, when it goes to the valuation, let's say that the hotel is by far the most valuable use, a hotel plus a theatre plus some offices, right? Is the willing buyer, willing seller thing assumption, then does the valuer have to assume that someone would want to buy it for that use? Or could the valuer say, yes, it would be much more valuable to build a hotel, but nobody would want to build a hotel on this particular spot. So the most that someone would be prepared to buy it for is a mixture of the education and the retail, and that's going to be your value.
The valuer's task, my lady, is to find the market value on the basis that permission for this range of uses could be achieved on the valuation date, would be achieved on the valuation date. And generally speaking, the market value will be the highest price that any purchaser is prepared to pay. The purchaser will form a view about what is the highest value development that on the portfolio of the certificate could be built. Because, and the valuer would do the same, because that is likely in valuation to be the price that the best purchaser will pay. Your example about the hotel raises, in valuation terms, something that I suspect is contradictory. Because if the hotel use is the most valuable on this site, it will be because hoteliers think that's a very good place to put a hotel. It may be that the local authority considers that this is a very good place for a hotel, and so hotel use is one of those uses that finds itself in the certificate, because as we thought, the certificate must include everything that the authority considers would get permission. But when the valuers come to look at it, when the market comes to look at it as at the valuation date, they say, well, very interesting that there's a hotel permission there. Understand why the authority would like it, but none of the hoteliers in the real world were interested in that site. And so what gives the value is the demand for offices or student accommodation or residential or whatever it may be and whatever mix may be.
Right, so there's no sort of assumptions brought to bear at that stage.
No assumptions about value are brought to bear at that stage.
Okay.
This is simply a question of what is the range of uses for which permission would have been granted on the valuation date had someone wanted to pursue that scheme. It is not, and this is a critical point in my submission, it is not an indication of anybody wanting to do that, wanting to produce a scheme with a hotel or any particular scheme. It's just saying, here are the range of possibilities, go ahead and value.
I mean, even in the real world, you can get multiple planning permissions for different schemes.
Yes.
And then if you're selling the property with a planning permission, it's for the market to decide which is the most valuable of those schemes.
Or the market may decide, and I had a case recently when we were successful for the authority arguing that despite the permission, the market would decide that the existing use was the highest value.
Okay, fine.
My next topic, as I say, was how, just to remind ourselves how we got to where we are. Appeals in respect of certificates were made to the upper tribunal in 2019 on all the 4 sites between May and August in 2019. And in his pleadings on all of those appeals, the Secretary of State argued, first, that in deciding the hypothetical planning application, the decision maker should take account of recent permissions and other applications before them, and that consequently, the decision maker of that hypothetical planning application is required to take account of recent CADs and CAD applications as material considerations. I derive those submissions from paragraph 7, for example, paragraph 71, 75, and 76 of the Secretary of State's pleading in my client's case, which is on pages 511 to 12 of the bundle. I don't ask you to turn it up. But I do say that or those propositions, namely that the CAD applications and decisions were material considerations of other sites, were material considerations in considering my site, was controversial. And it led the tribunal to the tribunal's decision to address it as a preliminary issue. Now, my lords, the preliminary issue is set out in a variety of places. I have it in paragraph 28 of the statement of agreed facts and issues.
I think that's a good place for us to...
and that, but I'm looking at it in the key documents. I need to just find, it's tab 4 for those who are still using the paper version, and it is, which is probably only me, page 217. Whether, I don't read every word, but I do read the words that I suggest are important. Whether, and if so, how, in determining the development for which planning permission could reasonably have been expected to be granted, the decision maker may take into account the development of other land where such development is proposed as alternative development in other CAD applications made or determined arising out of the same compulsory acquisition. So the question that we're actually asked to address is whether in deciding my CAD application, the decision maker may take account of the development of other land where that development is proposed as appropriate alternative development in other applications. The subject matter of the question is the development of the other land proposed in somebody else's CAD application on decision. And I say that, put another way, that question essentially is whether the inclusion of development in my neighbour's CAD application is a material consideration in considering the hypothetical planning application on my site. And I also say, in light of what my learned friend Mr. Cornus submitted yesterday, it occurs that that question is no longer controversial. He was asked what was unacceptable about the tribunal's formulation of its answer to the question. That formulation, again, is in a number of places. Page 350 is where the decision starts, and the answer is at paragraph 66 on page 364 and 365. So that formulation in paragraph 66 includes the proposition that CAD applications and decisions on other sites are not material planning considerations. My learned friend Mr. Corner took no issue with that. He did take issue about comments made in paragraph 64, which go to the discussion of fairness, but not with the tribunal's answer to the question and the key proposition that CAD applications and decisions on other sites aren't material planning considerations.
Well, I know you read that as meaning, that sentence as meaning that they're completely irrelevant and must therefore be left out of consideration, but that's not the flavour of the rest of the paragraph. That's the problem.
Well, Madam, I draw attention to that proposition as a stepping stone moving on. But I do say that the question as posed, in effect, is asking, are the developments proposed in my neighbour's CAD applications material considerations in the consideration of my planning application? That is the core of what the question asks, and the core answer is no, they're not material planning considerations. Now, I go further, but before I do, I say that what in effect has happened is that the Secretary of State has tried to change the focus. His focus is no longer on taking account of development proposed as AAD in other CAD applications. Effectively, he's asking a different question, which is something like, because there is a degree of elusiveness about what it is, but it's something like, could there be circumstances in which something contained in a CAD application or decision on Site A might have some relevance at Site B? And here, as I discern it, there are two main aspects. The first is that it may be that appended to my neighbour's application is a study which identifies the number of student bed places provided in Birmingham at a date close to my valuation date. Now, as long as that study is accurate, the facts disclosed in it represent facts known to the market at my valuation date, and so they fall to be taken into account. But that's not taking account of my neighbour's CAD application. It's taking account of the facts recorded in the study. The second aspect is that my learned friend appears to be saying that there is a period between the launch date and the valuation date, and the decision maker needs to populate that period with what would have happened in the interim. And he says, other people's CAD applications might give a steer of how that interim should be filled. Now, my learned friends have dealt amply with why that's not what Section 14 says, and why if you start recreating the past before the valuation date, you start giving yourself headaches that are just unfeasible. But I would add this, even if we are required to speculate on what would have happened between launch date and valuation date, CAD applications and decisions of my neighbours are not going to be helpful in the exercise. That's partly for the reasons that I paused earlier on a note about CAD applications, and for the reasons that are expanded upon in paragraphs 17 to 22 of my written case. Standing back and looking at this another way, the Secretary of State appears to be saying that the result of my CAD application can be altered depending on whether my neighbour has made a CAD application or not. In other words, that my neighbour's CAD application puts into the mind of the planning authority as at the valuation date something which otherwise wouldn't have been there. And We say Section 14 just simply doesn't allow that. I offer this, a proposition or a document or a piece of information which is independently verifiable as of relevance to my CAD application, because it evidences what was known to the market at my valuation date. That doesn't become inadmissible in my CAD proceedings simply because it was relied on in somebody else's proceedings. But a proposition, document, or piece of information does not, in my submission, gain status simply by being associated with or contained in my neighbour's CAD application. Thus, any proposition which is generated only by my neighbour's CAD application and doesn't have an existence independent of that is not relevant for the task set by Section 14.
So is this right, that you accept, in effect, that there may be cross-reference to materials adduced in support of other CAD applications, insofar as they may be indicative of facts known to the market at the relevant time?
It may be that a ready source of information that you could get elsewhere about the market has already been assembled by somebody else. You're not required to go out and assemble it again for yourself.
So I think you're answering yes to my question.
If that was your question, then I'm answering yes. So my evasion is doubt about the nature of your question rather than the doubt about the nature of my answer.
Okay, all right, thank you.
You're saying that the fact that it's been appended to or included in a CAD application makes no difference one way or the other to its evidential value? It's
entirely so. It is independent of the CAD application. And because the question ultimately, for this court, I say, the way it's now phrased by the Secretary of State, is whether association with my neighbour's CAD application makes relevant something that otherwise is not, the answer is no.
So what is the decision maker to do about the period, which can be quite a long period, between launch date and the valuation date? You say they're not entitled to speculate about what might have happened, but presumably they can take into account things that have actually happened in that period? Or how does that work?
It depends what you mean by things that have actually happened.
Well,
if they are things,
the market sales.
If they are things that actually happened but need to be ignored by reason of the Section 14(5) assumptions, then no, they're not to be taken into account. But if, for example, there had been a development permitted and built elsewhere in the city that sucks away a large proportion of the need for student accommodation, that would have been just our bad luck.
Right.
So, yes, things that have happened in the real world and are not scheme dependent are taken as having happened. So, and that is, in truth, likely to be the practice answer to the MSA example. And that will be that the Highways Authority of earmarked my land for highways improvement. And so the opportunity for it to be being used as an MSA has been taken away. And in the meantime, somebody at a lesser site has come forward and got permission for an MSA. And the existence of that permission, the fact that the MSA is being constructed, is part of the world in which my compensation is valued.
And the fact that but would that affect whether you got a certificate for a motorway service station? It would, I think you would say.
Potentially, if the justification for the motorway service station is a need, and that need has now been met or is now being met.
And it's irrelevant that in the real, that it had, if one were to look at what would have happened, that you might have got the permission first. It's all part of the swings and roundabouts, as it were, that you ignore. You don't speculate about, as it were, whether you've lost something, a valuable opportunity there, or you've... it can work either way.
It can work either way. At the launch date, for example, when we assume that the scheme has been cancelled, the local authority may lack a 5-year supply of housing, and at that date, you'd be quids in to get a permission for housing. But by the time we get to the valuation date, the 5-year land supply position has been rectified. You've lost out as a result of the moment being taken away from you, and you don't get compensated for it. That's the same as the MSA example, in effect.
Yeah. But when one's looking at what would have happened on the valuation date, so accepting the points that you've been making, one might, I'm not saying that it is this case, but one might be faced with a situation where, for various reasons, one would not necessarily accept that there should be developments, let's say, on 4 sites because of a restricted need in relation to some particular aspect of development. So is it not the case that as at that valuation date, even though in the MSA example no one has actually got planning permission for an MSA, one would look to see whether there was a reasonable prospect of other applications for other sites coming forward in assessing whether planning permission would be given for a particular site?
Well, one would approach the question, I think this is fear I'm doing no more than repeating the answer that Mr. Pereira gave earlier, so this may not be fully on your question. If that's the case, please forgive me, and I'll try and field better next time. But if on the application of normal planning considerations, issues relating to alternative sites or alternative proposals arise in the no-scheme world, they arise. But the fact of somebody else having made a CAD application is irrelevant to that question. We're not talking about how, in the question, how material considerations play out. The question is, even as framed by the Secretary of State, the question is, what is the factual matrix which one assumes before asking those questions about how normal planning rules play out? And in particular, is my neighbour's CAD application part of that matrix? And for the reasons that we regaled you with over the last nearly a day, we say no. And I'm very conscious, my Lord,
does that complete your submission?
I'm very conscious that yesterday you were not keen on our filling up the time to 11:30, and lo and behold, forgive me, we have. My learned friend, Mr. Elvin.
Just 1 minute before you pass the baton on.
Yes, I just wanted to check whether you wanted to say anything about the consistency argument, which I think is addressed by the upper tribunal at paragraphs 50 and 52. That seems to be
the consistency of decision making.
Yes.
Yes, thank you. The point that the Secretary of State seems to be making is, suppose that last week the tribunal decided a CAD appeal on a site acquired in the same authority area and in the same scheme. and that in these proceedings it concluded that on the 18th of March 2018, which is my valuation date, policy X was out of date. And so that's last week, and suppose that this week's CAD appeal in the same authority's area has a valuation date of the 17th of July 2018, and that policy X is also relevant. I would accept that the tribunal wouldn't ignore its reasoning in last week's decision. But I'd say two things. One, that's a set of circumstances that in my submission isn't raised by the preliminary issue as drafted, which is talking about taking account of the development of other land proposed in someone else's CAD. And the other point is what's happening in the example as I've set it up in a paradigm way is simply an indication to the parties in this week's appeal of the reasoning the tribunal will likely adopt on that common issue unless persuaded otherwise. So that's, in addition to what has been said by my learned friend, that's all I wish to add on that.
Thank you.
And my learned friend, Mr. Elvin, asked me to draw to your attention, which in the Lands Chamber, this is an embellishment on a submission I made, you will find the Secretary of State's submissions to the tribunal summarised in paragraph 35 of the tribunal's decision, pages 357 to 8 of the bundle.
Thank you very
Lord, my lady, thank you.
Now, yes, indeed. Thank you, Mr. Corner.
Thank you, my Lord. I wonder, Richard, if I can borrow. My Lord, in reply, I'd like to deal, if I may, with 7 topics, subject to your leave. Can I list them? 1, can the decision maker consider what would have happened in the no-scheme world?
Yes.
2, the role of CAD applications and decisions. 3,
Yep.
consistency. 4, does the cancellation assumption prevent CAD applications and decisions being taken into account? 5, Mr. Pereira's point about the reference in section 14.4a to development on the relevant land alone or together with other land. 6, one aspect of the debate about the effect of section 5a(2). And 7th, just briefly, equivalence and fairness. So I hope
This is a reply.
yes, it is. Yes. It is a reply. So I'll seek not to repeat what I've said, but I'm dealing with what my learned friends have said in relation to those topics. So 1 is, can the decision maker consider what would have occurred in the no-scheme world? I dealt with this yesterday because the respondents appeared to be saying no, the decision maker can't do that. I think, as a result of hearing the learned friends, that the second and third respondents agree that the decision maker is able to do that, but the first respondent does not agree it. So can I just touch on that topic, if I may? So the contention seems to be that if sites weren't available and proposals didn't exist in the real world, they have to be ignored because they were not circumstances known to the market at the valuation date. But the words of section 14 refer to development being AAD. If we look at 4b, on the assumptions set out in subsection 5, but otherwise in the circumstances known to the market at the valuation date. And those words can't mean that everything must be assumed to be as it actually was in the real world at the valuation date. Otherwise, the cancellation assumption in subsection 5, which requires a no-scheme world to be assumed, is ignored.
Well, obviously you make the cancellation assumption, but the argument is you don't do anything more than that. You don't start speculating as to what would have happened as a consequence of cancellation.
Well, that's the argument, but I say...
Well, what's your answer?
Well, I say applying the cancellation assumptions must mean looking at what would have been the situation had the scheme not existed at the valuation date. In other words, you are looking at a no-scheme world or a cancelled scheme world. You are... The scheme was assumed to have been cancelled on the launch date, and that must have consequences, or that must be able to have consequences. It must allow the decision maker to consider what sites would have been available in the no-scheme world for a particular type of development and with what capacity, and what proposals would likely have been brought forward on other sites. And this doesn't draw the decision maker into going back endlessly into history and letting its imagination take flight unto the clouds. What the statute has created is an assumption of cancellation on a particular date, on the launch date. We are not required to assume that the scheme never existed. So this exercise involves the decision maker going back to the launch date on which the scheme is assumed to be cancelled and asking what would the consequences have been had the scheme been cancelled, as the decision maker is required, I should say, to assume. And there are examples, I would suggest, of this being done in cases before the court. I would say ordinary examples of the decision maker looking at what would have been the situation assuming cancellation. Can I just mention two? They're both cases actually cited in their cases by the respondents. One of them is Leach, which is case B11 at page 895, and the other is Bolland, which is case B3 at page 700. Can I just begin by referring to Leach, if I may? If your lordships have Leach, it's, as I said, 895. May I summarise the facts? This is a case where the landowner applied for a CAD, and there was in place a structure plan policy setting out a policy for the extension of the greenbelt and giving general boundaries for that extension, but with precise boundaries to be defined later by local plans. And the claimant's site lay within the general boundaries set by the structure plan. So, in short, what the local planning authority decided in relation to the CAD application was that as the site fell within the general boundaries set out in the structure plan, the site should be regarded as being within the greenbelt, so no development would be permitted in the no-scheme world. So it issued a negative certificate. The upper tribunal dismissed the claimant's appeal and confirmed the negative certificate. Again, to summarise, in effect, the upper tribunal's approach was to start with the policy in the structure plan that the site was capable of being included in the greenbelt, and then to decide whether there was sufficient reason for concluding that when the boundaries of the greenbelt were finally determined, the site would be in it. And the Court of Appeal agreed that. It dismissed an appeal against the upper tribunal's decision. And I just wanted to ask your attention, if I might, to a short passage from Lord Justice Lewison.
And the reason why the boundaries were not actually fixed was because of the schemes?
No, it was because there hadn't been the local plans which were to fix the precise boundaries hadn't come in yet.
Right.
But Lord Lewison...
which paragraph?
Lord Justice Lewison, I'm so sorry, 34 I'm going to be looking at page 903, who gave the lead judgment. He referred to the upper tribunal's approach, and he refers at 33 on page 903 to the upper tribunal's, it proceeded to evaluate the 5 purposes of the Greenbelt laid down by the NPPF, and he sets out their conclusion there. And he said at 34, they also said that in the no-scheme world they were required to consider the land might have attracted a higher rating in terms of its fulfilment of Greenbelt policies. And, my Lord, it's a short point in Lord Justice Lewison's judgment, but I would suggest it's just an example of a perfectly ordinary approach of asking by the decision maker what would have been the situation in the no-scheme world. And the other example I was going to take you to, if I might, is Bolland, which is case B3, beginning at 700. This is Bridgend County Borough Council versus Michael Bolland and Magali Bolland. Begins at page 700. Again, a Court of Appeal case. Here, my lord, the issue was essentially what policies of the development plan should be disregarded due to the cancellation assumption. I.e., in essence, what the policy position should be assumed to be in the no-scheme world. And I just, again, if I may briefly summarise the facts. The claimant's site lay outside the settlement boundary of a village. And then in the development plan, the Bridgend Unitary Development Plan, there were introduced two new policies. One, a specific policy, SC 15, allocating the claimant's site for a new school. And two, also the settlement boundary was extended to include the claimant's site plus some other land to the north of it, known as the North Field. So the claimant applied for a certificate of a CAD for residential development. The planning authority issued a negative certificate saying that both the specific policy allocation and the extension of the boundary should be ignored. The upper tribunal disagreed.
And which are the relevant paragraphs you'd like us to go to?
I'm going from the head note, my lord. I'm looking at the third paragraph in the head note.
No, I beg your pardon. I was looking at the decision.
Yes.
In the body of the decision, which paragraph?
Well, it's under the factual.
No,
I'm so sorry.
You were going to refer us to some passages, I think, in the decision of the.
I am. Yes.
Yes.
I am. But in brief, if I can just, the Court of Appeal upheld the upper tribunal's decision that although on the cancellation assumption, the school-specific allocation had to be ignored, the extension of the settlement boundary did not have to be, and that is contained in the judgment of Lord Justice Hickinbottom. His reasoning is at paragraph 42, which is at page 708 to 709. Well, actually 708 to 710. And I wasn't going to, unless you wished me to, take you all through that reasoning. I don't think it's necessary for the purpose of this reply. But the case shows the decision maker having to deal with what, in effect, what would have been the situation, assuming the scheme to have been cancelled, albeit that that situation could be described as Lord Justice Hickinbottom did in the last paragraph on 709, the last subparagraph on 709, as a hypothetical and artificial world. It's, if your lordship looks at the last bullet point on 709, I appreciate, he says, third line down, that we're here concerned with a hypothetical and artificial world. But if the school scheme had been cancelled, it would have been a curious result if the rounding off Northfield could have been developed for housing and the northern Bolland land developed with at least education facilities, but permission for residential development of the reference land denied by virtue of the settlement boundary being drawn to exclude it and only it. In other words, the facts aren't really crucial for this purpose, but it just shows the process in which the court engaged, in which the decision maker engaged, and therefore with which the Court of Appeal was concerned on appeal.
But in either of these cases, was there argument about the correct approach?
I'm so sorry, but
Was there argument about what the correct approach should be in either of these cases?
I don't think in those cases it was suggested that the decision maker should do other than consider what would have been the situation in the no-scheme world. In other words, on the assumption that the scheme had been cancelled. I simply use them as an illustration of the approach that is taken and which I say is in principle, as a matter of principle, the right approach. If you are going to assume that the scheme has been cancelled on the launch date, you then have to, the decision maker, has to grapple with the consequences. Where would we be if the scheme had been cancelled on the launch date? And Fletcher, which I dealt with orally yesterday, which was deployed, it's B7 from memory. Fletcher, I only mention it now again because Mr. Pereira referred to it this morning. Fletcher does not run counter to the case I have been making. As Mr. Pereira fairly said, that was a case in which, at that time, the statutory cancellation assumption didn't exist. And the debate was, as between the acquiring authority and the landowner, do you assume, when you're assessing compensation, that the scheme never existed, has never existed? Or do you assume, as the Secretary of State in that case, as it happened to be, argued, that the scheme was cancelled at some stage? It was suggested cancelled at what we now call the launch date. And the court deprecated the assumption that the scheme had never existed. And because of the consequences of having to look back, way back, many years into the past, with all the difficulties that entailed. But that was why, it's because of those difficulties that the court decided to agree with the acquiring authority and say, right, in that case, we will decide the scheme should be assumed to be cancelled on what we now call the launch date. So the comments of Lord Hope, to which Mr. Pereira asked your attention this morning, to which he gave the references, are all in the context of the court being asked to adopt an approach that the scheme never existed, as opposed to adopting the approach which it did, that the scheme was cancelled on the launch date, which then shortens the period that you've got to be concerned with when you're asking what would have happened in the no-scheme world. So Fletcher, as I said yesterday, doesn't help the respondents. So that's all I wanted to say about point one. Can I turn to my second point, if I may? Role of CAD applications and decisions. CAD applications and decisions, we say, may be evidence of the availability of other sites and their suitability and capacity, and also the likelihood of proposals being made on such sites in the no-scheme world. A CAD application and the information in it could be, depending on the circumstances, evidence not just of the suitability or capacity of a site, but also evidence that a proposal for development would likely have been put forward in the no-scheme world. As my Lord Sales said during the discussion yesterday, in the real world, a developer will seek normally to maximise the value of their site. So also with a CAD application. Each case depends on its facts, and it's right that, as my Lady Rose said yesterday, you could have a case where it was very clear that a site owner really didn't want to bring forward their land for development for whatever reason, it doesn't matter. But in other circumstances, I say, the decision maker could conclude from the fact that a CAD application has been made, along with any other evidence in the case, that a proposal for the development would be likely to have been made in the no-scheme world. And as Lady Rose said this morning, if one of a number of potentially competing site owners makes a planning application, that might, in the real world, trigger others to make planning applications so as not to be, as it were, left out. So in that way, the CAD application itself can be relevant, and not just, as it were, the technical information that's contained in it. You can't divorce the two. Whether a CAD application does in fact comprise useful information, it's a matter for the decision maker. It may or it may not. And it's not our case to assume that CAD applications are going to be relevant evidence in all cases, or indeed any cases. That's for the decision maker. Just one or two other points on that. My learned friend Mr. Elvin said yesterday that CADs would not be known to the market at the time of valuation, because normally CADs applications would be made after the valuation date. Well, they might or might not be made after the valuation date, but my point is that they can be evidence of what would have been known to the market, not that they would necessarily have been known to the market themselves. My learned friend also said that the Secretary of State, I'm not using his precise words, I'm sure, but that can run a case about alternatives when a CAD application is being determined, but that the Rule 1 in Section 5, which talks about a willing seller, doesn't posit a willing seller on the other sites. In other words, you can't assume a willing seller on the other sites. And he followed that by saying whether the other sites would be available is a matter of judgment, decision, planning judgment for the decision maker. I agree. The decision maker will have to reach that judgment, taking into account CAD applications and decisions and any other evidence in the case.
But since it's irrelevant when making a CAD application whether you would have in fact made a real application in that situation or would have been able to, I don't see how any inference can be drawn from the fact that you do make a CAD application that there is either likelihood or availability.
Well, my Lord,
That's the basic problem I have with your case.
well, my Lord, let me seek to deal with it. If there is a CAD application, then it at the very least can show a site's suitability and capacity for development of a particular kind. Because if it's not suitable if it doesn't have capacity for the development that's referred to in the CAD application won't be granted. It simply won't be granted because the local authority will be unable to say that it would have got planning permission would have been granted for that development. If the site isn't suitable for the development, how can it get planning permission? It can't. But I go beyond that and I say that, depending on the circumstances, a CAD application, the making of a CAD application can, not always will, of course, but can show that in the no-scheme world, a proposal would have been likely to be brought forward. In other words, if a developer, we have 4 cleared sites here, as I understand it, owned by developers. As I understand it, there's no doubt that they would have brought forward, that they would have wished to develop their sites in the no-scheme world, had HS2 not purchased their sites. And they've made CAD applications for development of particular ranges, of particular types. And I say that the making of a CAD application by a landowner for a particular land use may assist the conclusion that, were it not for compulsory purchase, the land would have been put forward for that use. You might have a case, another case, where land is compulsorily purchased, the owner puts forward a planning application for residential development. Landowners are generally interested in maximising the value of their sites, perfectly rightly and understandably. A CAD application for residential development on a site may assist in determining whether in the no-scheme world a proposal would likely to have come forward for such development, just as a matter, I would say, of common sense. Mr. Elvin said also that CAD applications can be for a range of development. They can go beyond the planning application. True. But it will be for the decision maker to decide whether in any particular case the CAD application tells it anything useful, and development that's specified that by the authority that goes beyond the planning application, the application for the CAD, may not tell it anything useful. It all depends.
Does this risk opening up huge areas of contention between the parties, arguing over however many CAD applications there are, however many alternatives are set out in the application or in the decision, about what can be gleaned or inferred from what's in them and what can't?
Well,
is that really what was intended?
Milady, yes, it is to be taken as what was intended, frankly, because that's, as I said yesterday, the task of the decision maker is to decide what would have got planning permission, reasonably be expected to grant planning permission, had the scheme have been cancelled, assuming the scheme to have been cancelled, but otherwise in the circumstances known to the market. And so there will inevitably, or in many cases, be matters of evidence that need to be dealt with. And we can see in the various cases that are before the court, there is, in some cases, the need for evidence about matters, about what would have been the development for which planning permission would have been granted in the no-scheme world. But it's inevitable. It's just where we are. It's a consequence of the statute. And I was going to add that as Lord Sales pointed out a little earlier, it's right, of course, that CADs can be granted for a range of development, but so can planning permissions. Mr. Pereira said that CADs don't add anything to the rest of the available evidence. Why can't they? I say, as an example, a CAD may contain evidence about the capacity of a site for a particular development, which isn't to be found anywhere else. Just as an example. So it can't be said that a CAD doesn't add anything so as to justify the Court of Appeal's conclusion that you cannot take account of CADs or CAD applications.
But it would have to be known to the market at the relevant time.
Well, on the assumption, known to the market at the relevant time, but also taking into account the cancellation assumption, so that when you value the site...
Yeah, but your point about capacity...
Yes.
That would have to be known to the market at the relevant time.
Yes.
It simply comes out of a later CAD application.
Yes.
Doesn't help.
Well, if it comes out of a later CAD application, the CAD application, the capacity of the site will inevitably, its potential will inevitably be a matter which could have been known to the market at the relevant time, because the decision maker will have to look at, he's got to assume the decision maker has to assume the scheme is cancelled, has been cancelled on the launch date, and the decision maker then needs to ask, what would have been the potential contenders? What would their capacity have been? What would the suitability of the various sites have been? And it might well have been that had there been an application for planning permission in the no-scheme world for development on the relevant land, an alternative site assessment would have been asked for and submitted, which would have dealt with the capacity and suitability.
So it's not
of
just
other potential
circumstances
sites.
actually known to the market, it's circumstances that would or might have been known to the market on certain assumptions.
Well, yeah, because we have to take into account the application of the cancellation assumption.
But isn't the capacity of the proposed development partly dependent on them carrying out all the geological investigations and things which they say in the CAD application they're going to do? If they say the capacity is for a 20-storey accommodation block, subject, of course, to working out that the land can bear that, but they're not ever going to actually do that geological exploration, or so how accurate is it really as a
Well, it may or may not.
of the capacity of the site?
It may or may not be accurate, depending on the facts of the given case. But capacity doesn't necessarily depend on complex geological investigations. Capacity can be about the area of a site and how many, let's say, houses.
Yes, but that's something you can just look at the site and see, that you don't need the I'm just wondering what additional evidence a CAD application can give other than somebody just going to look at the site and survey it.
Well, it may give several types of information about the capacity and suitability of the site. For example, there might be traffic considerations of how much traffic the development would generate and its effect on the local highway network that have to be considered when one is dealing with the capacity of a site. And the CAD application may contain information about that, which would have been garnered on an alternative site assessment in the no-scheme world. Mr. Elvin reminded us that vesting dates are chosen by the acquiring authority. And yes, he's right. But as we've said in our case, where the valuation dates are far apart, or where there was a change in planning policy between the valuation dates for the several sites, the decision maker might decide that a CAD application on site 1 wasn't relevant to a CAD application on site 2. That's just the circumstance. We've covered that in our case at paragraph 151, which is in your bundle at page 263. Can I come back, just before I leave this second topic, to this question of whether a CAD application or decision is a material consideration?
A material planning consideration.
I'm sorry, material planning consideration, yeah. And I say not automatically of itself, and this is what I sought to say yesterday. Our point is CAD applications and decisions may be evidence of other sites or likely proposals which would themselves have been material to the assessment of the notional planning application on the relevant land. It's for the decision maker to decide whether CAD applications or decisions are such evidence of other sites or likely proposals, which would themselves be land use planning considerations, material to the decision on the notional planning application. Hence my answer to Lord Leggett when asked the question yesterday about whether I accepted the upper tribunal's answer to the preliminary issue. I prefer our formulation because the upper tribunal's answer says CAD applications are not material planning considerations, full stop, but then goes on, as Lady Rose pointed out this morning, to say, subject to those boundaries, it's for the decision maker to give the applications and decisions such evidential weight as they think appropriate. In other words, they're not ruling them out as relevant considerations. And so rather than getting into a perhaps slightly arid debate about whether it is a material planning consideration, I prefer our formulation. All a material planning consideration means is that it's a land use planning consideration which is relevant, material, to the determination of a planning application. That's all it means. There's no.
Say that again. All it means is that it's a land use.
Land use, a consideration relating to the use of land which may be material relevant to the determination of a planning application. I was going to turn to my third topic, if I may, which is consistency. I've largely dealt with this yesterday, and I only seek to reply to what was said. The Lord Sales asked whether, I think of Mr. Elvin, whether CAD's determinations are put on a planning register or put on a register of some kind. And Mr. Elvin said no, and I think he's right. I agree with that. So far as I'm aware, they're not. And then the Lord Sales said that, well, that makes it hard to know how consistency would work, or words to that effect, that I took it. And I would say it doesn't make it hard to know how the principle would work in principle. But in reality, in order for the legal expectation of consistency to be applied, the decision maker needs to know about the decision or have the means of knowing about it. To illustrate that, can I just briefly refer to the Baroness Cumberledge case, which is your B1 at beginning at page 631. And this, my lord, was a case in brief about whether the Secretary of State should have taken into account one of his earlier appeal decisions. So that's the territory we're in. And Lord Justice Lindblom dealt with the principle of consistency in this area at paragraph 34 at page 647. And if your lordship has that paragraph, at 34, he makes, I think it's 3 points. I've underlined them, so it's easy for me in a way. But the first is just below letter C in the left-hand margin. The second is just below letter D. And then there's a thirdly, about 6 lines up from the bottom of the paragraph, before the indented quote, I should say. And I don't think I need to trouble your lordship in reply with the first 2 points, because they're setting out the generality of the consistency principle. But Lord Justice Lindblom said, thirdly, the circumstances in which it can be unreasonable for the Secretary of State to fail to take into account a previous appeal decision that hasn't been brought to his notice by one of the parties will vary. But in tackling this question, it will be necessary for the court to consider whether the Secretary of State was actually aware or ought to have been aware of the previous decision. And then, Lord Justice Lindblom, if you'll permit me, I won't detain you with taking you through paragraph 35 and 36, but those are paragraphs in which Lord Justice Lindblom considers the extent to which the Secretary of State might have a duty, him or herself, to find out, to ascertain if there are relevant appeal decisions.
Is it part of your case that there is any inconsistency between the CAD decisions in this case? Or are you just raising it as an abstract question to invite our views about?
Well, they are, I suppose, consistent in that they all ignore the potential of the other sites.
So there is no inconsistency between them. It's a purely theoretical question.
Yes, but as I said yesterday, when framing this preliminary issue, We didn't expect an answer that would prevent the decision maker taking account of its previous decisions when dealing with determining a CAD application. But I say that is the result of what the Court of Appeal has said. It's not what the upper tribunal said. The upper tribunal, as we've already been told, at paragraph 50, specifically said, accepted that the decision maker can take account of its own, can take account of determined CAD, of CAD determinations, of CAD decisions. But the Court of Appeal said you can't in any circumstances. I suggest that is a matter of legitimate concern.
But what you're not saying, as I understand it, is that it is inconsistent for the decision maker to grant CADs for 4 times the planning policy amount of student accommodation. You're not relying on the consistency with the planning policy or something like that.
They were, in a sense, consistent, and they were all, if I may say so, consistently wrong, because they all refused to take any, in all 4 decisions, the planning authority refused to take any account of the potential of other sites, the neighbouring sites, to take up the need for accommodation.
But I mean, insofar as there's a consistency point, it seems very different from the Baroness Cumberledge sort of point. I mean, it's not as though in one CAD determination policy has been given a meaning which has been departed from in another.
Well, I don't
you seem to be, when you were just talking about consistency there, you seem to be using it in a different sense from the consistency principle as, well, as I rather read the tribunal as referring to it, and as we've been debating in this hearing.
Well, I think the consistency principle is somewhat different from what the upper tribunal said at 50. The upper tribunal wasn't dealing with, at 50, what it said is, if one looks at the end of 50, sorry, page 361, what the upper tribunal said, if one looks at the latter part of that paragraph, is that a decision on an adjoining site, which has been arrived at applying the same statutory assumptions and which has resulted in the granting of a real CAD, positive or negative, is capable of being relied on as evidence of how, in the world of the cancelled scheme, the local planning authority might reasonably have been expected to deal with an application for planning permission on the relevant land. And I say that's clearly correct, if I may say so respectfully to the upper tribunal. I agree. But that will be ruled out by what the Court of Appeal said. But there is also
accept that it's not a consequence of that they have to regard the need as having been diminished by that CAD.
No. What I said yesterday was, and it's in our case at paragraphs 121 onwards, a CAD does not use up capacity, and every time the local authority, the decision maker, deals with a CAD application, it has to make the best decision it can on the evidence available to it. That's why so that's not like a planning permission in the real world, which you can build. But that's why some of the objections that were raised in the Court of Appeal to our case are not valid, because developers do not need to fear that the grant of a CAD, which they didn't know about or just happened before their CAD application was considered, will use up capacity. It doesn't. nobody's really argued before this court that it does.
Well, if you haven't argued it, nobody else is going to.
Well, hopefully not. Hopefully not. But that was a fear that was raised, which I am saying is an unwarranted fear. And you will see deployed in Lord Justice Lewiston's judgment that, if you like, fear, that because of the fear that capacity would be used up by an earlier grant of a CAD, he said, well, various consequences flow. I say, no, they don't, with very respect. Consistency, just to seek to finish my answer to Lord Sale's question. Consistency, my Lord, yes, I agree, is not necessarily the same as the point which the upper tribunal was making in paragraph 50. But this is a preliminary issue, and the Court of Appeal has laid down a rule which prevents previous CAD decisions being taken into account. And one of the points that I'm making is that rule stands in the way of the application of the consistency principle. For example, you might have a case of a CAD where a particular interpretation of a policy, a decision is based on a particular interpretation of a policy, let's say by the upper tribunal. Should not the upper tribunal be expected to adopt the same interpretation in its next decision, or if not, give reasons for not doing so? I mean, that's what the consistency principle is. I mean, in this case, we've got the upper tribunal has before it appeals in respect of all four sides, as I said yesterday. If the Court of Appeal is correct,
I think you made the point about 10 times by now that the Court of Appeal would rule out consistency.
I'll move on. I'll move on.
I think we've understood it.
I'll move on. Thank you very much. Sorry to tire you. Right, let me move on then to my fourth topic, cancellation. Does the cancellation assumption prevent CAD applications or decisions from being taken into account? Lord, again, I'm not going to repeat all that I said yesterday, but simply to make the point that Section 14.4b defines AAD, in other words, development for which planning permission could reasonably have been expected at the valuation date on the assumptions set out in subsection 5, cancellation, but otherwise in the circumstances known to the market at the valuation date. And then you assume, if development is AAD, you then assume under 14 subsection 3 that planning permission is either in force or that it's certain that it won't be granted at a later date. And so it is simply, 14.4b is dealing with the definition of AAD. It is that which is to be ascertained. It is not dealing with the evidence that can or can't be used to ascertain that thing. And, my Lord, I say that to the local, the legislature, had it wanted to, it could have stopped, it could have legislated to stop anything that arose from the compulsory purchase being taken into account for any purpose. It could have said that, and it didn't. And to stretch the words of 14.4b, to the extent that the respondents wish, is, I suggest, to stretch them further than their natural meaning and further than the objective behind the cancellation assumption, which is to prevent the scheme of works having an impact on value by affecting what would otherwise be the potential of the land. I don't think I can add, my Lord, to that. Our argument is, I hope, fully set out in our case, in addition to what I've said orally. So thank you. So I move on then to my fifth point, which is the reference in section 14.4a to development on the relevant land alone or together with the other land, together with other land. Will your Lordship just give me one moment, if I may? Mr. Pereira said yesterday that the reference in section 14.4 to alone or together with other land makes clear that other land, apart from the relevant land that is to be considered only if it's part of the same notional planning application as that on the relevant land. Not so. The reference to together with other land in 14.4a is a reference to the point in that was established and set out in a case called Sutton, which is referred to in our case. I'll give the reference in a minute if I may. But the point being that it may be material that planning permission could be granted for the relevant land as part of a larger area. This is in our case at paragraph 79 to 80, page 244. And the case of Sutton is there referred to and quoted from at footnote 1. So that's it's a reference. It's an attempt to take account of that principle. It may be material that planning permission could be granted for the relevant land as part of a larger area, but as we say in our case in the last sentence of 80, that does not prevent other sites or proposals being relevant when it's being determined what planning permission could reasonably be expected on the relevant land alone or together with other land. In other words, 14.4a tells you the thing you have to assess: the likelihood of planning permission being granted on the relevant land alone or together with other land. My case is that other sites and CAD applications and decisions on other sites may be relevant to the assessment of that likelihood. That's all I seek to say, my Lord, on that point. I come then to my sixth point, which I said is just one aspect of section of the discussion about section 5a, subsection 2. My Lord, this is a reference to yesterday I drew attention to paragraph 53 of Lord Justice Lewison's judgment. In our case, which is at 337, I think. Yes, it is. This is where he said that to take account of CAD applications and decisions would contravene Section 5A, subsection 2 of the 1961 Act. And, my Lord, I set out yesterday in detail, and I won't repeat, because we've also set this out in our case, as to why, with respect, his argument is not correct. But I also said yesterday that in any event, this point can't be a reason to defeat our appeal and uphold the Court of Appeal's answer to the preliminary issue. Because CAD applications can be made as from the launch date, so before the valuation date. And my learned friend, Mr. Elvin, said, well, I was wrong, and that a CAD application couldn't, in essence, be determined until the valuation date. And I just say two things about that, if I may. What I said, or meant to say, was a CAD application can be made at any time after the launch date. It might not be decided until after the valuation date, but it can be made. And I say CAD applications can be relevant evidence. And in any event, CAD decisions could be made on other sites on or after their valuation dates, but before the valuation date for another site, to which they may be relevant. That's all I seek to say, my Lord. I won't, as I say, repeat what I said in relation to the point actually made by Lord Justice Lewison in my case and yesterday. And I come then to Section 7, equivalence and fairness. And it's really a response to something that Mr. Pereira said. He appeared to suggest that if his case leads to CADs being issued for, in the present case that is, more student accommodation than the overall need, then that's fair compensation to the landowners for the fact that their land is being taken by compulsion. In reply, I would say that we can all have our own views about what would be fair, but we have to follow the legislation. And my case is based on what I suggest is the proper construction of the relevant legislative provisions. Would your Lordship just give me one moment while I just check if there's anything else that I need to say? I think I'm still within my time limit. Am I?
I think we'd be grateful for you to, subject to any further questions.
Grateful for you to stop.
for any concise further point you may have, but otherwise I think we've covered the ground pretty thoroughly.
Right. Would your Lordships just give me one moment? My Lord, Thank you very much indeed, all of you, for your patience and for your questions. Very grateful. Thank you.
Well, thank you all very much. May we take it then that application will be on its way to our registry?
Yes. Once you rise, I'm sure that we will get our heads together and get this material to you dead quickly.
I've just been reading it again while Leonard was on his feet, so I'll speak to him about it as soon as he was.
Thank you.
Very grateful. Thank you all very much for your extremely helpful submissions, both in writing and in response to our questions and orally. We will consider all of them with great care, and we will let you have our judgment as soon as we can.